Hello, family. Welcome back to the Bible News and Worship Network. You know, in my years of ministry, I have had the profound privilege of standing at the altar with young families. I've held their infants in my arms, dedicating them to the Lord. I have walked alongside parents as they embrace one of life's most sacred callings. The Bible is absolutely clear on this. It is the God-given responsibility of parents, mothers and fathers, to raise their children in the training and instruction of the Lord. This isn't a suggestion, friends. It is a divine mandate. It is a sacred trust to shepherd the hearts and minds of the next generation. But I have a difficult question for you today. What happens when that sacred trust is deemed a threat by the government? What happens when a mother reading the Bible to her child is treated not as a fulfillment of her duty, but as a source of harm? Today, we are discussing a story out of the state of Maine that should shock the conscience of every Christian family in America. It is the story of a mother named Emily Bickford, a mother who has been ordered by a court of law to stop taking her 12-year-old daughter to church. She is forbidden from reading the Bible with her. She is, effectively, being penalized by the state for being a Christian. My friends, before we can understand the war, we must understand the battlefield. The facts of the Bickford versus Bradeen case are not just legal details, they are the anatomy of an attack on religious freedom. For 3 years, Emily and her daughter Ava faithfully attended Calvary Chapel. As young Ava grew in her faith, she made the beautiful, personal decision to be baptized. But when she shared this news with her father, he was reportedly enraged and initiated legal action. What followed belongs in a novel about a totalitarian state, not a family court in the United States of America. The father's legal team reportedly brought in a Marxist former sociology professor. This so-called expert testified that Bible-believing churches like Calvary Chapel are cults and are psychologically detrimental, and the lower court accepted this hostile testimony. The judge delivered a finding so chilling, it should stop every believer in their tracks. In essence, the judge declared Emily Bickford to be, quote, a fit parent, except for the fact that she is a Christian. Let that sink in. Her fitness as a mother was not questioned, except for the defining element of her identity, her faith in Jesus Christ. The court order prohibits Emily from taking Ava to church without the father's approval. It is so broad it could prevent Ava from seeing Christian friends or even attending Christmas services. And most shockingly, the order dictates that Ava is not allowed to read the Bible. This injustice in Maine is an assault on a principle foundational to both our faith and our nation's laws. Long before the Constitution was written, the Word of God established that the duty to instruct children rests with parents, not kings, not governors, and certainly not judges. But legally, we must understand that parental rights are a constitutionally protected fortress. First, our authority comes from God. He commissions parents as the primary spiritual guides. The state's role is to protect that relationship, not usurp it. Second, the U.S. Supreme Court has long recognized, in landmark cases like Meyer v. Nebraska and Pierce v. Society of Sisters, that the right of parents to direct the upbringing of their children is a fundamental liberty interest protected by the 14th Amendment. This isn't a privilege the government grants you, it is a freedom they are forbidden from taking away. And finally, we have the First Amendment. The Free Exercise Clause specifically protects a parent's ability to share religious doctrine with their child. When you open the scriptures with your son or daughter, you are exercising a specifically enumerated constitutional right. Now, does the state have a role in protecting children? Of course. We thank God for laws against abuse and neglect. But the Constitution builds a high wall to protect the family from unwarranted intrusion. For a court to breach that wall, it must meet a standard known as strict scrutiny. It cannot act on a whim or bias. There must be proof of severe, demonstrable harm. The harm must be demonstrable, quantifiable, severe, and imminent. The evidence must be objective. It cannot be based on the subjective prejudices of a judge or a Marxist professor. So, let's look at the alleged harm in the Bickford case. According to reports, the evidence amounted to claims that the child, at one time, was observed to have anxiety, left notes around the house, and saw a scary demon image in a workbook. Is this imminent and substantial harm? Is this the kind of severe threat that justifies stripping a fit mother of her constitutional right to share her faith? Of course not. It is a tragically low bar that makes a mockery of the high constitutional standard. There is a critical line here, family. A court can regulate harmful conduct, but it has no authority to censor belief. The judiciary is, in the words of constitutional experts, constitutionally barred from acting as a theological arbiter. Yet that is exactly what the lower court in Maine did. It listened to biased testimony, weighed the content of the Christian faith, and found it wanting. The court's remedy reveals its true intent. A narrowly tailored solution to a child's anxiety might involve counseling. But this court used a sledgehammer. It banned church. It banned Christian fellowship. It banned the Bible. This was not a surgical intervention to prevent harm. It was a blunt, unconstitutional instrument of religious censorship. And when a court bans the Bible in one home, it creates a precedent that threatens every Christian home. This is a slippery slope. While the Bickford case is shocking, it is not entirely unique. We see a pattern where courts use the vague best interests of the child standard to impose secular biases. In Nebraska, in the case Burnham vs. Burnham, a mother lost custody based on her unusual religious beliefs, not because of actual harm, but because of speculative adverse impact. Legal scholars call this a flagrant abuse of the court's power. It allows judges to substitute their own personal prejudices for constitutional law. In the Bickford case, a father reportedly found an ACLU judge and a Marxist professor to redefine biblical truth as a psychological threat. This is a strategy to marginalize Christianity in the public square. Emily Bickford is a fit, loving mother. Her attorney, Matt Staver of Liberty Counsel, calls this order unconstitutional and devastatingly heart-wrenching. So, what must our response be? First, pray fervently. Lift up Emily and Ava. Pray for their peace. Pray for the Maine Supreme Judicial Court, that they would have the courage to uphold the Constitution. Second, stand firm in your home. Do not be intimidated. Embrace your God-given responsibility. Teach the Scriptures. Your home is your first ministry. And finally, be vigilant. Watch what happens in your local courts. We must be watchmen on the wall. Our hope is not in courts, but in the sovereign God who ordained the family. Let us be a people of faith, not of fear. For the Bible News and Worship Network, I'm Pastor G. May God bless you, and may God protect our families.